Hi, I'm going to talk about the case Board of Regents versus Roth. This case was heard by the Supreme Court in 1972, and Justice Stewart gives the majority opinion. So this is also an interesting case. It's about a man named David Roth who worked for Wisconsin State University in Oshkosh, and he was hired for a fixed academic year, September 1st, 1968 to June 30th, 1969. He completed his term, but he was informed that he would not be rehired. So because he didn't have tenure, which takes 4 years to acquire, he was not entitled to a hearing or any sort of excuse for him to be, well, for his contract to not be renewed. Um, Non-tenured are protected during employment, but not after their scheduled employment ceases and they essentially do not work there anymore. So they have to be informed by February 1st as a non-tenured employee, and he was contacted by the president of the school and was told that he was not going to be rehired. So Roth filed a lawsuit against the state or against the university and said that it violated his 14th Amendment rights on two accounts. It said that it violated his freedom of speech because he claimed that he was being fired for remarks that he made about the university that were not favorable, and so that violated his freedom of speech, and it also violated his right to due process because he was not given any sort of hearing. He wasn't given a reason for his termination. Well, it's not even termination, it's just not renewal. So anyway, he said that that's why he was filing the lawsuit. So anyway, it was taken to, well, it went through the first court, which upheld the Board of Regents, and then it went to the Court of Appeals, which sided with Roth and said that he was owed an explanation for his non-renewal, and then it looks like the Board of Regents actually appealed that decision, so that's why it went to the Supreme Court, and that's why it says Board of Regents versus Roth instead of the other way around. And this is where Justice Stewart said that he was not owed an excuse for his contract not being renewed. And I just circled a couple of quotes here that I thought were really, helpful. So he says, liberty and property are broad and majestic terms. They are among the great constitutional concepts purposely left to gather meaning from experience. They relate to the whole domain of social and economic facts, and the statesmen who founded this nation knew too well that only a stagnant society remains unchanged. That's from the National Mutual Insurance Company versus Tidewater Transfer Company. And so, for that reason, the court has fully and finally rejected the wooden distinction between rights and privileges that once seemed to govern the applicability of procedural due process rights. So basically, he's just saying that, he's trying to define what liberty and property are, and he's saying that David Roth doesn't have any sort of right to this, intellectual property, and that he feels that he is owed some sort of explanation, and he is owed some sort of due process for being for his contract not being renewed. He's not owed that. So I'll just read a couple other quotes here. It says, there is no suggestion that the state, in declining to re-employ the respondent, imposed on him a stigma, or otherwise, sorry, I just lost my place, or other disability that foreclosed his freedom to take advantage of other employment opportunities. The state, for example, did not invoke any regulations to bar the respondent from all other public employment in state universities. Had it done so, this again would be a different case. So I think that is, that's a good point. He's welcome to work anywhere else. He had a 1-year contract. He fulfilled his contract. The school fulfilled their contract, I'm sure, in paying him and providing him whatever benefits that go with that contract. Because they didn't decide that they wanted him, he can't really sue them. He has no grounds. They don't owe him anything more than what was in the contract. They don't owe him an explanation. And here's where it comes full circle with the liberty and property definitions. So I'll read this one last quote. Hence, on the record before us, all that clearly appears is that the respondent was not rehired for 1 year at one university. It stretches the concept too far to suggest that a person is deprived of liberty when he simply is not rehired in one job, but remains as free as before to seek another. So I thought that was also a really great quote. Anyway, that is what I have for the Board of Regents versus Roth. I think that the Supreme Court once again made the right decision in agreeing with the court, and thanks very much.